since I finished updating them. All right, chapter 11, landlord and tenant law. So this chapter is all about leases. It's all about the leasing process. It's all about taking real property and transferring not ownership, but a temporary interest. See, that's phrasing they might use on the test. I'm not trying to talk above your head. I'm trying to give you the phrasing that you might see on an exam. Transferring a temporary interest in real estate. What's the one-word definition? What did I just define? A what? A lease. A lease is a transfer of a temporary interest. A transfer of a permanent interest would be ownership, right? What's another word for ownership that we talked about way back in chapter 2? Freehold. So what do you think this chapter deals with? Non-freehold. These are your non-freehold estates. Remember that word estate. Don't forget this. But you may see that on an exam. What is an estate when you see that word? It's a relationship. It's a legal relationship that somebody has to a property. So if they have a non-freehold estate, they simply what? They lease it. That's the best way to describe someone who has a lease. The legal way to describe it is that they have a non-freehold estate. Sounds fancy, it's not. Lease it. They're a tenant. If they have a non-freehold estate, they are a tenant. The tenant has a non-freehold estate. What does the landlord have? They have a freehold estate because they own the property. See the difference between the two? Everybody okay with that? All right. So tenants have non-freehold estates. Landlord has freehold estates. We're going to talk about 4 different structures for leases. Now these have nothing to do with how the rent gets paid. We're going to talk about that separately in a later section. These structures deal with how the lease ends. They don't deal with how the lease runs while it's going. Pretty much every lease works in exactly the same manner while it's going on. The major differences in leases come when they end. So on a test, and we're going to talk about each one of these separately, but on a test you're going to have to identify, is this a tenancy for years? Is this a periodic tenancy? Is it a tenancy at will? Is it a tenancy or an estate at sufferance? We could use estate, by the way. Everywhere you see tenancy, we could use the word estate. Estate for years and tenancy for years means the exact same thing, because estate just means a relationship. Okay? So a periodic tenancy is the same thing as an estate for period to period. An estate for years is the same thing as a tenancy for years. You can just substitute those words out. Is everybody all right with that? When you get that test question, what should you focus on when you're trying to identify these 4 things? Before we even talk about what the differences are, what should you be focused on? How the lease operates or how the lease ends? Ends. That's what matters. That's the thing that matters about these different lease structures, is how they end. What happens when we want these things to terminate? Not how they get started, not how long they last. That's another thing they love to prey on your innocence on these exams. An estate for years or tenancy for years, they're going to prey on you on that. You're smart enough at this point to see what they're going to prey on. They're going to prey on what? What word are they going to prey on in that? Years. They're going to give you something that lasts for a number of what? Years, and expect you to identify what type of tenancy it is. Here's the thing. It doesn't matter that it's for years, because the how it operates has nothing to do at all with the type of lease it is. The length of time has nothing to do with the type of lease it is. If you're trying to determine if it's a tenancy for years, what should you be looking at? How it ends. If you're trying to determine if it's a periodic tenancy, what should you be looking at? How it ends. If you're trying to look at it and determine if it's a tenancy at will, you should be looking at what? How it ends. It's always about how it ends. Are you with me? Okay? So let's talk about the 4 of them and talk about how they end. I'm also going to try to help identify with you where they're most commonly used, what type of real estate transactions they're most commonly used in. The estate for years, or tenancy for years. First of all, it has nothing to do with the length of time. The estate for years, we said what matters? How it what? Ends. Here's how it ends. Automatically and without notice. Period. It's over. It ends automatically and without notice. And when I talk about notice in this chapter, notice works the same way whether you are the landlord or the tenant. If we say the tenant has to give notice, then who also has to give notice? The landlord does. If we say the landlord has to give notice, then who also has to give notice? The tenant. You cannot structure a lease legally where those rules are different from one side or the other. There's no such thing as a lease where the landlord doesn't have to give notice, but the tenant does have to give notice. That doesn't exist. Are y'all with me? The law says this has to be a fair playing game here. We've got to have a fair playing field. It's got to be even. So if the landlord has to give notice, it's only fair that the tenant also has to give notice. And guess what the notice time frames are going to be? Exactly the same. They got to be equal. What did I say about this one, though? It has no what? No notice. No notice. None. Zero. None. Zero. None. Absolutely no notice required. This is a lease that's for an exact period of time, and everybody knows on the day it begins exactly how long it's going to be for, because it's going to end without what? Without notice. We know the day it starts exactly how long that tenant's going to be in that property, because this lease ends without notice. Does that make sense to everybody? Now, let me ask you a question. How many of you have leased property residentially in this state? Does that sound like a lease you have ever had in residential property? That it ends exactly without any notice from anybody. Does that sound like a residential lease? It better not, because it can't be. This is not a residential lease in North Carolina. In North Carolina, residential leases are what we call periodic tenancies, which is the next one we're going to talk about. Because you have to give what? Notice for them to end. If you don't give notice with a residential lease, what does it do? It renews. What you all did was jump to how it renews. Oh, it goes to month. But what it does is it renews itself. If you never give notice, what does the lease continue to do every month? It renews itself. This doesn't happen. On the day after this expires, if nobody gives notice, you know what you refer to the person who was the tenant? A trespasser. There is no notice. You are expected to know when that lease expires, and you're expected to do what? Get out. That is the estate for years. Where do you think this is most commonly used? Commercial real estate. Commercial real estate, commercial transactions are almost always estates for years. Why do you think they would be structured in that way? Do you think we would expect a business owner to have more knowledge about when their lease ends than we would a residential tenant, for example? Yeah. Do you think that the law cares less about protecting business owners than it does residential tenants? Yes. Absolutely. See, the laws are set up to protect residential tenants. There are no such laws set up to protect you if you're operating a business. If you're operating a business and your lease expires, you're expected to know that and do something about it. So, could I have a conversation with my landlord about renewing this lease? Yes. Would I have to if I wanted this lease to renew? Yes. Now, are they obligated to renew? No, of course not. They never are. Could they have a conversation with me about renewing the lease? Sure they could. If neither one of us has a conversation with the other, though, what is this lease going to do? It's going to expire, terminate, end. It's over. You have no legal right to be in that property any longer. Does that make sense for everybody? Okay? So we understand. Travis leases a beach house for a definite period of 2 weeks. This is an example of What is it? Tenants, Travis leases a property for an exact period of 2 weeks. This is an example of. This is an estate for what? Years. What is the key phrasing there that you refuse to focus on? Exact. This is the only lease in the world that is for an exact period of time. That's what I'm trying to ram home by yelling it at you. There's only one that the instant the tenant moves in, you know the instant that they're also doing what? Moving out. And that's the estate for years. It's the only one that works that way. So any exact period. And I know you just hate to say it's an estate for years because it's for what? 2 weeks. But guess what? That's exactly what it is. An estate for years is any exact period of time that ends. If for it to be this next thing, the periodic tenancy, there would have to be some statement about what? What's the key difference here? What about renewal though? What do we need to give here? We need notice. Because if we don't have notice here, what does it do? It renews. Stop saying month to month because you don't know that. That's an assumption. Could it renew year to year? Absolutely, because that's what the lease could say. All we know is that if it's a periodic tenancy, that if we don't give notice, it's going to what? Renew itself. It doesn't end on an exact date. It ends whenever either the tenant or the landlord do what with each other? Give notice to each other. I don't care that it has a time period printed on the lease. That's not an exact date because it doesn't end unless they also take the step of doing what? Giving notice. Yes, the lease may say 1 year, but could that same lease last 20 years? Yes, if they don't ever do what? Give notice. If they don't ever give notice to each other and the tenant continues to pay rent and the landlord continues to accept rent, is this lease going to continue indefinitely forever? Yes. That is what makes it different than the estate for years. Does that make sense for everybody? So the way that you would see this described on a test is it would have to say something about giving notice to terminate or automatic renewal. Either one of those phrases makes it definitively a periodic tenancy. If it doesn't say anything about either one of those, what is it most likely? An estate for years or a tenancy for years. Does that make sense for everybody? If it doesn't say anything about automatic renewal, it doesn't say anything about giving notice to renew, it's most likely, in fact, it has to be, a tenancy for years. If it does say something about having to give some kind of notice to terminate, or automatic renewal, because some of those mean the same thing. Automatic renewal means I need to give notice if I want it to do what? Terminate. Does that make sense? If you don't give notice to terminate, it automatically what? Renews. Talk about this one. If you don't give notice, it automatically what? Terminates. So in this one, you would only give notice if you wanted to what? To renew. In the estate for years, you would only give notice or talk to the landlord if you wanted to do what with the lease? Renew. If you don't want to renew, you just make the assumption they know you're leaving at the end of the month or the end of the year, or whatever it happens to be. Whereas in this one, if you don't want it to renew, you better get in touch with somebody and say, I do not want my lease to renew. Does that make sense for everybody? And like any other contract, where would you look first for the rules about how much notice you needed to give? At the contract, which in this case is the what? The lease. Just like when we talk about fixtures. Yeah, we teach you a bunch of rules about fixtures, but what's the first place you look to see if something's a fixture or not? At the contract, because the contract probably specifies or may specify that thing is a fixture, is not a fixture. You only worry about the rules if the contract doesn't what? Doesn't specify. Same thing is true with leases. There are going to be rules about notice. We're going to talk about them in just a second. Minimum notice. But could the contract, could the lease specify more notice that the parties need to give each other? Yes. And do you think they often do? Yes. It is very common to see leases specify more than the minimum notice time period. And so you have to follow first whatever the written lease says. You only worry about these minimums that we're going to talk about here if there is no written lease, or if the written lease doesn't mention how much notice needs to be given. Is everybody okay? All right. So let's talk about that notice to terminate. Now remember, you only follow these rules if, it's a big if the lease doesn't what? Doesn't specify, doesn't state how much notice has to be given. If the lease does specify or state how much notice has to be given, then you don't worry about these rules. You follow whatever the lease says. And if it's 30 days notice for the tenant, it's also 30 days notice for who? The landlord. Is everybody with me on that? So these are the minimum notice periods in a periodic tenancy. Remember, there's no notice in an estate for years, right? None. These are only for periodic tenancies in North Carolina. And this is North Carolina specific. Landlord and tenant law varies a lot from state to state. So almost any landlord-tenant law question you get would be in the state-specific section of the exam, because there's very little that can show up about landlord-tenant law in a national section, because the laws vary so much from state to state. So that sort of makes these questions even more important, right? Because they're on the harder section of the exam to deal with anyway. So in North Carolina, if you're dealing with a periodic tenancy, or period to period, you got to give notice to terminate. The state says that these are the minimum notice periods. If you have leased that property week to week tenancy, what does it say the minimum notice period is? 2 days. How about month to month? 7 days, or year to year. Oh, really what the statute says is anything longer than month to month. What's the minimum notice period for anything longer than month to month? 1 month. Minimum. Could the lease specify 60 days notice? Absolutely. And if it does, how much notice does the tenant have to give? How much notice does the landlord have to give? 60 days. And if they don't give that notice, what happens to the lease? It renews. It renews. That's why when you have one of these leases, it is very important to keep up to date with your lease expiration if you want to get what? If you want it to renew, or if you want to get out of it? If you want to get out of it. It's very important to keep up with your lease expiration in this one if you want to do what with it? If you want to renew it. Because this one's going to end with no notice. If nobody talks about this one, it's going to what? It's going to renew. And you will have clients, folks. This is not important for you just if you go into property management. Do you think you're going to deal with leases even as a sales agent? If you're helping people buy houses, are you going to deal with leases? Yeah, because what are they probably coming out of in a lot of cases? A lease. Do they understand landlord-tenant law? No. And so you better. You better. Because if you haven't had a conversation with them and said the simplest of things, like, have you given your landlord what? Notice. How much how much notice does your lease require? What does your lease say about notice? Those are conversations you need to be having with a buyer who's coming out of a rented property, folks, because if they don't give notice, what could their lease do? It could renew. And could the lease specify that it renews to year? Absolutely. So could they be stuck with another whole year of that lease simply because they did not give notice to the landlord that they intended for it to terminate? Are y'all with me on this? You've got to be able to identify the difference between these two on a test. You're certainly going to see that as a test question, no doubt. Now, month to month is the default periodic tenancy. Sort of by default, and default means if you don't have a written contract that specifies something different. Does that make sense for everybody? So by default, if you don't have a written contract that specifies something different, you're going to get what? Month to month. If you want anything other than a month-to-month tenancy, you need a written lease. Now let me ask you this question. See how much you're paying attention. Can you have oral leases in North Carolina? Yes. Yes. But what are they going to be? They're not only oral, but they are what? Month to month. no matter what kind of property you're leasing. So if I leased a commercial property with an oral lease, what kind of lease would we have? Month to month. Which means the lease would automatically do what at the end of every month? Renew, unless we give what? Notice. Now let's go back. Let's say we have that oral lease that is automatically what if it's oral? Month to month. What is the minimum notice period for month to month? 7 days. So put it all together now. If you have an oral lease, you're going to have a what kind of lease? Month to month with how much minimum notice required? 7 days, because that's what the state says is the default for if you don't have anything in writing. If you don't put it in writing, you're going to have a month-to-month tenancy with 7 days minimum notice to terminate. Yes, sir, Dave.
So what's the advantage of that? If it's not in writing, you can't go to court.
You can go to court. You can go to court. That's a great question, actually. The question was, what's the advantage of that? If it's not in writing, I can't go to court. And that's actually incorrect. We can go to court with an oral lease because, and so here's, I'm going to bring up another thing. Leases are not covered by the statute of frauds in North Carolina, which means they don't have to be what? In writing in order to be enforceable. But what the state says is that the state's not going to enforce a bunch of stuff that you discussed orally. The only thing the state is going to enforce is going to be month to month, 7 day minimum notice. So if you want anything other than that, what had you better do? Put it in writing. Put it in writing. That also brings us to a really important point. I got you each second. The only thing the state of North Carolina, see, this is a double-edged sword. Sometimes people hear, oh, well, you know, I still have an enforceable lease because North Carolina honors oral leases. Yeah, that cuts both ways. Because North Carolina honors oral leases, it's not required for somebody to produce a lease in court to show that you are bound to a lease. Are you following me on that? Because a court can enforce an oral lease. Can you think of a time where a landlord might accept rent, but not the whole month's rent? Just like a little tiny portion of rent. When might that happen? Move in or prorated? How about move out? How about they're supposed to be out on the 30th and you go over there on the 3rd and they're still there? Does that happen sometimes? Yeah. And they're in the process of moving out, but they're still there. And they say, I'm sorry, I know we're supposed to be out. Here's $100. Pay you for these 3 days. No. No. And no. Because you just created an oral lease in North Carolina. And oral leases are what by default? Month to month. How much did you just lease that? How long of a period of time did you just lease that property for? A month. For how much? $100. And not only did you lease it for a month, you leased it for a month and it automatically does what at the end of the month? Renews for another $100. Unless you again provide written notice that you expect the tenancy to end. Never accept a partial rent payment in this state. Do not do it. I'm sorry? Never accept a partial rent payment, period. Ever. Ever. Because you just renegotiated the lease amount. Yes, ma'am?
If you actually create a different kind of agreement and do like a week-to-week for them, would they still be able to stay for the 30 days? Or
No, if you remember, an oral lease is only in absence of a what? Of a written one. Could you create a written lease contract?
Yes.
The answer is you couldn't. Who could? An attorney. And they're going to charge you a couple $1,000s to draw up that agreement so you can collect $200 in rent. So what are we right back to? Never accept a partial rent payment. When they offer you the $100, say no, get out. No, get out. I do not want your $100. I want you out. Do not pass go. Do not collect $200. That's an old reference if you don't. Get out. Because I'm telling you, landlord-tenant law is not set up to protect the landlord, folks. It's set up to protect who? The tenant. It always defaults to protecting the tenant. Now, I'm not saying that to be critical of tenants. I'm saying that because as real estate brokers, you're almost never going to find yourself on the tenant side. If you work with leases, what side are you going to be on? The landlord side. So you have to start thinking about what is best for who? The landlord. And the worst thing you can do on a landlord's behalf is accept a partial rent payment. Just don't do it. And I've had people say, well, I do it all the time, I've never had a problem. And again, I go back to my same analogy. People speed every day on the Beltline and don't have a problem, but eventually they get what? They get caught. And if your job is to represent the landlord's best interest, what's going to happen when you have that tenant who took Travis's class? Because is there somebody in this room that's thinking to themselves, I'm going to do that to my landlord next time? Yeah. I guarantee you one of them's thinking it right now. You might not admit to it, but you are. Right? So you're going to run, eventually you're going to run across a tenant that does know tenant law in North Carolina. And they're going to offer that $100 as bait, hoping you take it. And as soon as you do, they're going to say, by the way, I'll see you next month when I pay you my $100 rent again. Hold on, let me get Jocelyn Shatter hand up.
Okay, like in my example, you know, that I leased. I signed the lease 4 years ago. And he wanted to renew the lease, and I said no, because I didn't want to be bound to stay. I mean, I wanted to have the option if I ever want to move to stay.
Okay.
But then it says here, since I'm month to month, but in reality, he can give you a 7-day,
That is not what it says there.
oh, okay.
What did I say you always look at first?
I got lost.
The contract.
Okay.
Do you have a written lease?
Yes, it's small, but I have one.
There's no such thing. I see right there. That's where I can tell you she's going to miss the test question. Because she said 2. Yes, but you have to know that. You have to know that because you said 2 things that I have to correct you on instantly. First of all, you said you didn't renew it. Well, what the hell are you, trespassing?
No.
Then what did it do?
I renewed.
It renewed. Now, you didn't renew it for as long of a period as maybe the landlord wanted, but you did absolutely what? Renew it. So then you proceeded to, because you built on the wrong idea that you didn't renew the lease, you said, I have a lease, but it's old. Is it old? No, because it's current, because it's been what? It's been renewed. So how much notice does Jocelyn have to give? Whatever notice is specified in that written lease, because that written lease is still in existence, because it has done what with itself every month? It has renewed itself. That is still the lease. That is the lease. There's no such thing as an old one if she's still there. That's the key about this thing. It never dies unless you kill it. You got to pull the trigger. And how do you pull the trigger? You give notice to what? Terminate. To the landlord you say, I am moving out. Or the landlord gives what? Notice to you that they are terminating the lease. So now go back. What is your written lease specify as far as notice? 30 days. So right now, and I'm assuming it also specifies that it renews itself as month to month.
I don't think it goes that much into detail, but most likely.
Okay, if it doesn't go that much into detail, then how does it renew itself? What's the default if the lease doesn't specify? Month to month, okay? So we'll assume that it's renewing as month to month, because most of them specify that in writing. And if they don't specify in writing, it would be month to month anyway. Does that make sense? So it's month to month with how much of a notice period? 1 month. And that works for you and for the landlord. And see, that's the thing that you have to make the connection with leases. People say, well, I'd rather be month to month because I don't want to get locked into anything. They're having the exact same conversation on the other side, folks. Because if you're not locked in, they're not locked in. They're locked in exactly the same as you are and vice versa. That's the way leases work. Is everybody with me on that? So just like you could give 30 days notice at any time that you wanted to terminate, they can give you 30 days notice at any time that they want you out. And so that's the risk you have to weigh if you want to get more peace of mind that you might not have to move on 30 days notice. Then you need to execute what? A new lease with a longer period of time. Yes, ma'am. I'll get John.
you know, I'm not in the, it's been years since I've leased, but I hear some of my friends that lease, if they don't renew it and they go month to month, can they charge you extra, like they give you a choice?
If it's specified where?
In the lease. But
In the lease.
Is that possible? I mean,
If it's, of course it is, if it's specified in the lease, because again, nobody's your mama. Nobody's here to protect you. When you sign that lease, was that language in there that said if you allow this thing to go month to month, the rent will escalate to this amount? Absolutely. Now, if that's not in the written lease, then no, they can't do that. They can simply either have you renew at a higher amount, or they can give you notice to terminate. But if the lease already specifies in advance that at the end of this lease it's going to renew as month to month, and the month rate goes from $1,100 to $1,500, then that's what the tenant and landlord agreed to at the beginning, so that's what's going to follow through. Does that make sense for you? So you always want to go back. One of the major problems that people run into with landlord-tenant law is they look like anything else. They look for what they think is most advantageous to them. Right? If it's the tenant, they almost always go run scrambling and they look at landlord-tenant law because they're like, ooh, it says you got to do this. Ooh, it says you got to do that. Yeah, except you signed a lease that says the exact opposite. And most of the time, if you agree to it, then it's possible. And so what I would say is go look at the lease. Yes, sir, John.
Oh.
You good now? Okay. Yes, ma'am.
For the landlord, as far as recourse, in the scenario that they accepted the $100, if they want to go, like, can they take that to court and be like, well, they only gave me $100, they didn't pay the full value of a month's time for that 30 days? Can they actually go and sue for the difference?
No, because they accepted the $100. That's exactly it. So what they can do is not repeat the mistake for another month. Once the landlord has realized they've done that, what should they immediately give to the tenant? Written notice, and let's do this again next month. Next time, make sure they're out of there at the appointed time. Yeah, Tom.
Now, what happens if you want to pay for like 2 months, and I give them like all the money 2 months, and they say, well, this is going for 1 month?
Well, in that case, it's a really good question. If you've made a payment in advance, again, the laws generally are written to benefit the tenant, not the landlord. So if the landlord tried to indicate that you had renegotiated the lease like that, I doubt any judge in this state would agree with that. I think almost any judge. Now, the best way to handle that, if you intend to pay 2 months at a time, whether you pay with a check or a money order or Venmo or PayPal, whatever you use, put a notation on there. You know, that's what memo lines on checks are great, right? Because you can put down there, this is for August and September 2018 rent. You know, so but you can do that on any kind of electronic payment service. You can do it on money orders. Don't pay cash. Cash is a bad idea because it's just not traceable, not trackable, not, you know, it's very easy for people to say didn't give it to them. You know, use some type of something that has a record, even if you have to go to Walmart and get a money order for 39 cents. You know, just do that and put down in the memo line, you know, this is rent for August and September 2018. That way there'd be no doubt about it, because that would make it clear in writing what the intent was. That'd be the best way to handle that. Yep.
So if it is month to month, and you're not supposed to, the landlord is not supposed to accept a partial like $100 payment because it is month to month. We measure it in exact months.
Yep.
Then isn't it equal relationship? The other way is true. If you pay 2 months, since it's month to month, not 2 months to 2 months, couldn't the same thing be true from the landlord to tenant relationship?
I don't know what you're asking.
So like, all right, so if I pay $100, say, hey, I'm gonna be here another week, here's $100, and you accept it.
Yep.
And then I'd be like, ha, sucker, I got another month for $100. Then isn't it the opposite true? If I say, hey, here's double the money for 2 months, couldn't you be like, ha, sucker, I just...
No, because you're saying it, which is oral. And what is the state of North Carolina going to enforce in an oral lease? That's exactly right. So what is the state of North Carolina going to enforce? What are they going to say you have? They're going to say you have a 1 month lease, month to month, for whatever amount was exchanged.
Right, exactly. Okay, so you can't really pay 2 months. You can't.
Sure, you can if you do it. If you do it with some sort of a written evidence of what it's for.
Okay, so the memo line on a check would be considered.
Absolutely, that's written evidence, absolutely, absolutely. In fact, a check has been, let's be clear about this, a check can be a contract. A check absolutely has been enforced in this state as a sales contract. I'll give you an example. This happened in Wilson County. Thank you. This happened in Wilson County, North Carolina. Somebody met over lunch and discussed selling their family farm. Met a friend of theirs over lunch, discussed selling their family farm. They agreed on a price. And once they agreed on the price, the buyer, the proposed buyer, took out their checkbook and wrote a check for $15,000 for a deposit on the purchase. And here's what he wrote on the memo line. He wrote, for purchase of Ellis Family Farm on Highway 42, $85,000 remaining balance, because the agreed purchase price was $100,000, and he was paying a $15,000 deposit. He wrote a deposit check to the seller for $15,000. He wrote, purchase of Ellis Farm on Highway 42 in Wilson County, remaining balance $85,000. Signed the check, gave it to the buyer. Seller. Seller deposited the check the next day. A month later, seller changed their mind because they realized they had drastically undervalued the farm and refused to sell. The buyer sued them. What kind of lawsuit is that? A suit for what? Specific performance. When the buyer is suing the seller to force them to sell. And here's the argument that the seller's attorney made in court. It actually went to court, and the seller's attorney made an argument that there was no contract because the North Carolina statute of frauds requires a real estate sales contract to what? Be in writing. And a judge pulled out the rules for the statute of frauds regarding real estate sales contracts. And it simply said it must identify the property. Does it? Yes. It said it must identify the grantor and grantee. Does it? It said it must have the signature of both the buyer and the seller. Does it? Because it has the buyer's signature on the front of the check, and who signed it on the back? The seller when they did what? When they deposited it. And does it identify the consideration or purchase price of the property? Yeah, because if you do the math and say this is a $15,000 deposit with $85,000 remaining balance, the contract's for how much? $100,000. And the North Carolina court said that's a written enforceable sales contract in North Carolina. Now, I don't recommend you handle it that way. It would not be a good idea, but it is enough. And so those are powerful things when you put those kind of notations on things. Yes?
Now, with that same scenario, had you not cashed it, is it still okay?
If you had not cashed it, it probably would have not been considered a sales contract because it would have been missing the buyer's signature. There would have been no buyer's signature on it. So it would have failed on one of the... You couldn't have shown that there was a meeting of the minds because, in essence, anybody could write you a check and just hand it to you. But if you don't cash it, if you don't deposit it, there's no evidence that you actually agree with what they wrote down.
What about if it's missing a little description?
If it's missing any of those, that's the whole point. It has to have all of those things, and it has all of them. So, when you have clients write due diligence fees, what should be in the memo line? DD fee, the address. Make sure it clearly identifies what it's for. Yes, sir.
And so the contract doesn't necessarily have to be one of those.
Doesn't have to be a 10-page pre-printed agreement. That's exactly right.
Approved by the bar and so
That's exactly right. It does if we use it, if we utilize it as a broker, but it's up to a court of law to determine what is the minimum bar acceptable.
So was there a question to the condition of the seller who made that agreement, or was that part of it, like his?
No, they never made the claim. That's a good question. As far as I know, they never made the claim that the seller didn't know what they were doing. The only claim was or that they weren't out in their right mind, or they were drunk or intoxicated or not competent. The only argument was they didn't know what it was worth. $100,000 sounded good to them at the time. Once they started talking to other people, they realized the value was more like $250,000 based on the cost of acreage in the area. And so they simply said, well, no, I'm not selling to you for that now. And the buyer made an argument that we have a written contract, and ultimately ended up in court. The court of law agreed with the buyer. And so in this case, not only did the seller have to sell their property for $100,000, they had to pay all the court costs and all the attorney's fees for both sides too. So that was an expensive mistake. Yep. Okay. Are we all good? We all good on these types of these two main categories of leases? Now let me be real honest with you. I'm gonna back up here. We said there were 4 different types, right? How many have we covered? 2. These really are the only 2. For practical purposes, these other 2 exist more just in legalese mindset than they do in real life. Pretty much every real lease where rent is being paid is either an estate for years, which means it's for a very definite period of time, it automatically terminates with no notice required, or a periodic tenancy where the end is sort of open-ended because it automatically does what with itself? It renews itself unless either landlord or tenant gives notice. Does that make sense for everybody? Now, the much less common ones, the ones that really only exist in courtrooms, I mean, they could exist in the real world, they do exist in the real world, but you're not going to deal with them in the real world. The estate at will. At will. When you can do something at will, what can you do? At your choice, at your leisure. You can change your mind. So, the whole idea of a lease or any other contract is to prevent you from doing what? Changing your mind. An estate at will is one where you're absolutely allowed to change your mind. And since we have to be fair, if the tenant can change their mind, who can also change their mind? The landlord. So this is basically permission to occupy the property. Permission to be in possession of the property. Remember, be in possession of means occupy. Permission to occupy the property. And the thing about permission is it can be given at any time, but it can also be what? Taken away at any time. It's at will. There is no commitment from either the property owner, the landlord, or the tenant. There's no commitment from one side to the other. It is simply permission to stay there. Now, the truth is, the vast majority of the time, this is going to be for free. And here's why. If you pay rent, what does the state say you have if you don't have a written agreement otherwise? You have a month-to-month periodic tenancy. Does that make sense? So if somebody just gives you rent, you're not going to have an estate at will. You're going to have a what? A month-to-month periodic tenancy. Does that make sense for everybody? So the only way you could have one of these where rent was being paid is if you had a written agreement drawn up that makes it clear that this is an estate at will. Now, that's going to be very rare. I mean, who's going to go pay an attorney to draft an agreement that gives people permission to do nothing, right? That's simply to say they can walk away at any time they want to. So the vast majority of the time, in order for it to be an estate of will, what's the key thing you're going to recognize? Know what's being paid. No money. No money being exchanged. So it's permission to stay there. You might do this. Let's say you have a property that needs a lot of maintenance. It needs a lot of work. Are there people who will allow somebody to stay there in exchange for them fixing up the property? That would be an estate at will. Here's the deal. The tenant doesn't owe the landlord anything, and the landlord doesn't owe the tenant anything. They are doing it because they both want to. And either can do what at any time? Change their mind and move out, and neither can hold each other responsible for any rental period. Does that make sense for everybody? That is an estate at will. It's permission to occupy the property. It's not for a certain amount of time. It's not, doesn't require notice. It's literally just until either or changes their mind. Yes?
Is that something that you think you should have some type of thing in writing as well?
Well, I think it's always best to have something in writing, especially if you have any expectation of holding them to anything. So even like, for example, damages to the property. If you don't have anything in writing, you're not going to be able to hold somebody responsible for damages to a property. So even if you were doing a tenancy at will, it might be a good idea to have it in writing, even if they're not paying rent, just in case they damage the property. You know, because what if they agree to move in there and they're going to fix up the property in exchange for staying there for free, and they do more damage to it than they fix? Is that possible? It is. And could you hold them responsible for it if you didn't have something in writing? No, absolutely not. Yes?
So how can you give something with no notice of
You just leave.
an agreed upon end?
You just leave.
Or what about the,
They call until you get out.
like today?
Tomorrow. Today. Now. It's at will. It's until somebody changes their mind. So you would never do this as a legitimate way of leasing a property. This is not a legitimate method to accomplish leasing a property. You would never do this with a property somebody lives in, for example, because they can't get out on a moment's notice of something they live in, you know. And so, again, does this sound like something that you're going to come across in the real world? No, not in any sense as a real estate broker. Because if you've been hired as a real estate broker, number one, what are you going to be collecting every month? Rent. You were hired to collect rent if you're going to be a property manager. So you're never going to deal with this as a property owner. On a test, which is the only place you could ever have to deal with this, you would identify it by simply noting that there's no commitment between either one. Neither one is committed to each other for any time period. In a state, for years, they've committed for a definite time period. A periodic tenancy, they've committed for an ongoing, unknown time period. And a state at will, they've not committed at all to anything. Everybody okay with that? And then the last one, the estate at sufferance. This is what apparently Jocelyn is. No, she's really not. Because we've established that her lease has done what? It has renewed. It has renewed. The estate at sufferance, another word for these people are trespassers. They're actually one step above trespassers. They're one step above trespassers. The only difference between an estate at sufferance and a trespasser is a trespasser never had the legal right to be there at all. What do you think an estate at sufferance is? Somebody that had the legal right at one point, but what? But stayed. They have overstayed their welcome. So if it was an estate for years, they're there past the expiration date. Because an estate for years does what on its expiration date? It ends. So you show up 2 days later, they're still there. They are a tenant at sufferance. Does that make sense? If it was a periodic tenancy, they stayed past what? Past the notice period. They've been given notice properly in writing that the landlord wanted them out, and they haven't done what? They haven't left by that time frame. That's a tenant at sufferance. Okay? These are the ones you have to be very wary of, because these are the ones that will want to pay a partial rent payment. And if you take that partial rent payment, they go straight from being at sufferance to what? They go back to periodic tenancy. Month to month. Okay? So a big key of estate at sufferance is no rent. We call them holdover tenants sometimes too.
And these ones are the ones that are hard to get out. So this is like people when they start giving them notice to change their tenants, they have like 3 or 4 months to live it out. It's going to take the court process a bit long.
Okay, are you asking, is the eviction process slow? Because there was a lot in there. Are you asking if the eviction process is slow? 45 days. 45 days on average. In North Carolina, it's 45 days. We're going to talk about that. Yeah.
So you saying categorically those people that have some.
Categorically, anybody who holds over past the end of their lease is a tenant at sufferance. I'm sorry? Yes, and you still have to go through the eviction process. There's no simple resolution to getting a tenant out who does not want to leave on their own recognizance. And let's be clear about that too. We're going to talk about in just a second what the legal remedies are. What does a remedy mean? The solution to a tenant who won't leave. And the court system has a legal remedy. It's the eviction process. We call it summary ejectment in North Carolina. Here's the thing. Just because that is the court's remedy does not mean that should be your first remedy as a property manager. The best way for a tenant to vacate the property, by far, is of their own accord, is of their own volition, is them deciding to leave. And whatever you can do as a property manager legally, notice I said legally, that encourages that decision is a better way to go. And I will tell you, as somebody with experience in property management, particularly on the residential side, you attract a lot more flies with honey than you do vinegar. There's an old Southern expression for you. That means take the exact opposite approach of what you think will work. What you think will work is showing up and yelling and screaming and going to the courthouse and filing all this mess. It will work, but it will be slow and it will be expensive. you can take a different approach. It will not make you feel good. You will hate yourself for doing it. You will smile at them and you will want to slap them at the same time, but you can't do that. But if you can come to an agreement where they will voluntarily vacate the property, that is always a better result than going to court. I'm going to give you an example of what I mean. What's the most common reason you think we evict a tenant? Non-payment of rent. Yeah, runaway favorite. There are a lot of reasons we evict tenants, but 95% of all eviction procedures are centered around, maybe 99%, non-payment of rent. Now, you have to be at least 10 days late on the rent in order to file in North Carolina. You can't file for ejectment or eviction of a tenant in North Carolina unless they're 10 days late on the rent. But most landlords do not go and file at 10 days late because filing is a pain in the rear end. You got to go to the courthouse, you're filing a lawsuit. Is there a fee associated with that? Yeah, it's about $500. It's about $500 that the landlord has to pay in cash, and they only take cash, by the way, at the county courthouse. They have an ATM in the hallway that charges a very reasonable $12 fee if you don't have cash on you. But it costs you about $500 between the actual filing fee and the service fees, because you have to pay the sheriff's department to serve that tenant with the notice of the eviction hearing or the summary ejectment hearing. So you have to pay for the service, and if you've got 4 tenants, how many services do you have to pay for? 4 of them. And if their parents co-signed for them and their parents live in another state, do you have to pay for service in those other states as well? Does that get expensive? Yeah, $50 a pop for the service. And then the actual court filing fee itself. So, and that's money the landlord has to pay out of their pocket. Now remember, they're there because they already aren't getting what? Their money. So there's another $500 we have flushed down the toilet of life, right there, just in the filing fee. So most landlords do not file when a tenant's 10 days past due because they're hoping the tenant will do what? Well, they're really hoping to catch up. Catch up. That's what you generally hope they do, is they catch up. Most landlords do not file until the tenant is at least 30 days past due. It's usually the second month that rent doesn't show up that you start to get that sense of panic as a landlord. And that's what, so most of them file when the tenant's already a month or 2 past due. We'll just say 1. So they're a month past due. Is everybody with me on that? And let's say the rent is $1,000 a month. So we're owed $1,000. Now we go file. We pay $500 to file. So we're out how much money? $1,500. Now, the process takes 45 days. So, now keep in mind, they have gotten a visit now from the county sheriff notifying them that you have filed a lawsuit against them. Are they going to be very happy-go-lucky and pay you rent the remainder of their time there? No, you're not going to see any more rent. Once you file, you can forget that. The rent's not coming. I can tell you that. So now we got another month and a half worth of rent that's going to go unpaid before we finally get the summary ejectment hearing. Y'all follow me on this? If you're doing the math, how much are we out now? $3,000, right? We're out $3,000 when we just get to the summary ejectment hearing. Are you with me? Now, they don't even bother to show up for the summary ejectment because they know they're going to lose. You still have to. So you wasted your day to go. You show up. You get possession of the property. Now you have to arrange a time to meet the sheriff because you can't go in the property until the sheriff goes with you. So you got to arrange another time to meet the sheriff's deputy over at the property so you can get access back to the property so they can document that you've legally taken possession back of the property. Let me ask you, what condition is that property going to be in? Tore up. Or as my grandfather would say, toe up from the flow up. You know, right? Because they know that they're not getting their security deposit back because they know they owe you rent, right? So they've already counted their security deposit as being gone. They're mad that you're kicking them out. They are not going to clean up. They're going to leave you a mess. Does that make sense for everybody? So now you've got another 2-3 weeks worth of cleanup, the cost of cleanup before you can get the property re-rented. So you miss a whole another month worth of rent. Now how much money are we out? $4,000. Say it costs us $500 to clean it up. Well, how much? $4,500. That is the reality of a summary judgment right there. And yes, I can go back to court and I can get a judgment against that person for that $4,500. In my experience, that's only going to be another $500 that I wasted in a filing fee, because you're never going to see that money. They're not going to pay it. Some do, but the vast majority do not. That is $4,500 that landlord's never going to see again. Is everybody with me on that? Here's a different approach. When they're late and you've decided, okay, it's time to do something, we have to get them out. So say they're 30 days late, they owe you $1,000. You go knock on the door. And when they come to the door, because they know why you're there, when they come to the door, you say, listen, I understand it happens to everybody, but we need to come up with a solution. So here's my solution for you. We're holding $1,000 of yours as a security deposit. Now you owe us $1,000 in rent. I'm willing to forgive the $1,000 you owe us in rent, and I'm willing to write you a check for your security deposit and refund it in full if you're out of here by Friday and the house is in immaculate condition. And I will give you a good reference when you come home so you can find somewhere else. So your choice is, you can get your $1,000 back on Friday and go rent something else, or we can go through a month-and-a-half court process where you're going to have an eviction on your record, you're not going to be able to rent anything, and you're not going to get your money back. Which would you like to do? Now, a lot of people, when you suggest giving money back to a tenant that already owes you money, would freak out. Well, let me ask you a question. If they owe me $1,000 and I give them their security deposit back, but they leave the thing in good condition, how much money have I lost? $1,000. That's it. I lost $1,000 in rent that I forgave. Maybe even if I let them stay 2 weeks, I lost $1,500 in rent, but now I know the property's going to be in what kind of condition? Immaculate, so I can do what? Re-rent it instantly. Which is a better outcome for the landlord? You see what I mean? Just because there is a court process does not mean it should be the one you should default to, especially as a property manager. As a property manager, you have to learn to come up with creative solutions to those problems, to figure out what's the best way forward and what's going to maximize the return for that owner, because that's your job at that point. It's a tough business. It's a very tough business. All right, let's do this. Let's take your first break, come back at 20 minutes till, and we'll talk about the payment structures of leases.
I had some apartments when I first moved here. Back in the early 90s, we first came up on a triplex. And people weren't paying rent.